The morning Vivian served me divorce papers, she wore earrings from our 10th anniversary. She placed them on the kitchen counter in Chestnut Hill like a restaurant bill, efficient and decisive, without room for discussion. Her lawyer had already been hired, boxes were already packed, and Prescott Harlow, her former trainer who turned into an obsession, apparently awaited outside. I didn't weep or plead. At 43, a federal prosecutor for the Eastern District of Pennsylvania, I'd spent nearly 2 decades persuading juries to accept facts they preferred to deny. So I examined those papers, looked at my wife of 11 years, and asked simply, "Are you certain?" She chuckled, as if my question was the climax of a joke she'd been saving for months. "Garrison," she replied, grabbing her keys. In my entire life, I've never felt so certain about anything. However, she was mistaken on that count. She was wrong about numerous things, but it wasn't until she found herself in a courtroom in Center City, Philadelphia, that the truth unfolded. As the federal judge read charges she hadn't anticipated, her attorney's countenance paled, and the accusations didn't concern me at all. But let's step back a bit. I've been trying to shake off my courtroom habit of jumping ahead for 20 years now. Let me start from the beginning. If you're new here, subscribe and leave a comment letting me know where you're tuning in from. Today, we delve into my story. My name is Garrison Wyatt. I was raised in Kensington, Philadelphia, not the glossy image people have of Pennsylvania, but the raw version. The one with chain-link fences, corner stores, and men who worked until their bodies gave out and then continued laboring more. My father, Raymond Wyatt, drove a city bus for 3 decades. Every evening from 11 to 7, my mother Darlene maintained offices in the financial district. Upon her return, she prepared our breakfast before we departed for school. We weren't impoverished in the dramatic sense portrayed on TV. Instead, we experienced a quiet form of poverty, one characterized by a constant shortage of resources and a keen awareness of dignity as something to be crafted from meager means. Our family had ample food, but scarcely enough, heating functional most winters, and we learned early the importance of self-worth through limited resources. My academic success was due to school being tuition-free and the availability of books at the Allegheny Avenue Library. I excelled enough to secure a scholarship to Temple, then another opportunity to attend Penn Law. I was tenacious enough to decline 3 times the compensation offered by a private firm, insisting on prosecuting individuals who warranted incarceration. This determination cost me dearly throughout my life, but ultimately protected me as well. At an old city fundraiser, I encountered Vivian Darrow, a renowned interior designer whose clientele resembled an elite social register. Striking in her effortless elegance and possessing a contagious laugh, Vivian once harbored a fascination for prosecutors in their initial stages. She admired my work defending the defenseless, but 11 years later, she dismissed me as dull-witted. Indeed, both sentiments may hold truth. Our marriage had been disintegrating undetected for approximately 2 years prior to her serving me with divorce papers. However, engrossed in 60-hour weeks on federal cases, I returned home to a house, not a relationship. Vivian had attempted to voice her concerns, but when conversations hold little hope of change, they become empty expressions. She'd express feelings of solitude, yet the marriage was already beyond repair. She suggested she grasped it. I suggested she desired more depth. I indicated events would decelerate. They remained accelerated. Entering the scene approximately half a year and a half prior to the divorce was Prescott Harlow. Vivian commenced training with him thrice weekly at a gym in Rittenhouse Square. He was 36, 7 years junior to Vivian, emanating an assuredness stemming from unrealized plans never requiring more than charisma. He drove a leased Porsche and broadcasted motivational mantras on Instagram at 6 in the morning. Vivian began returning home later and later from these sessions. I was aware of it, as one becomes conscious of things not yet ripe for action. The bank statements revealed unaccounted expenditures. The instance when she claimed to be visiting her college friend Naomi in Wilmington, except Naomi had phoned the house asking for Vivian on that very day. An aroma unfamiliar to our home pervaded the atmosphere. I accumulated these fragments much like a lawyer collects evidence during federal investigations. Steadily, discreetly, without tipping my hand until the opportune time arrived. The opportune time in this instance being the divorce proceedings themselves. However, before that time, something else transpired. Something that altered every calculation Vivian had ever made regarding our separation. My grandfather passed away. Theodore Wyatt was not a man whose wealth was anticipated. He spent 4 decades managing a plumbing supply business from a warehouse in Port Richmond, the kind of area that carries the scent of the Delaware River in summer and old machine oil all year round. He drove the same Buick for 16 years. He carried his lunch in a paper bag every workday of his life. He wore the same 3 shirts on a rotating basis. He was the type of man who scrutinized receipts with the same gravity that others reserved for legal papers. Remarkably, what nobody, including my father, knew until the reading of the will was that Theodore Wyatt had been discreetly amassing Philadelphia real estate since 1971. Primarily commercial properties were his focus. A warehouse in Fishtown he acquired for a minimal price and held onto across 3 different economic fluctuations. A row of mixed-use storefronts on Passyunk Avenue. A parking lot in Fairmount whose land was eventually deemed extremely valuable. He never disclosed any of this. Not a word about money, except to note that the key to amassing wealth lay in not spending it on unnecessary items. Upon his death from a heart attack in February, he died alone at the house in Mayfair where he'd resided since 1968. The estate was valued at $4.2 million and bequeathed to me. Not my father, who had his own feelings about that. Not to my uncle Terence, who owed Theodore money on 3 separate occasions and failed to repay a single cent of it. To Garrison Raymond Wyatt, designated in a meticulously crafted, amended, and notarized will, reflecting a man who had pondered this very circumstance for decades. The will came with a letter. Theodore's handwriting was minute and cautious, that of a thrifty individual mindful of ink consumption. "Garrison," it started, "you're the only one who inquired about how I established my business rather than simply seeking financial gain from it. That query is worth more than you comprehend. Prevent anyone from seizing what I'm bequeathing to you, and do not feel remorseful over those who believe they are entitled to it." Worth and effort are not synonymous. I perused that letter in my grandfather's Mayfair kitchen, enveloped by 6 decades of collected everyday life. The same kitchen table where he had instructed me chess, the very coffee maker he'd used since the early 90s, the same drapes my grandmother had hung before her demise. I perused the document thrice before tucking it away in my jacket pocket. From the funeral home's parking lot, I phoned Daniel Rourke, my attorney. "I require your counsel on asset protection," I stated. "The divorce process is ongoing. Are there any potential issues I should be aware of?" Daniel paused in a way lawyers do when preparing to present complex information. "When did Theodore pass away, Garrison?" "This morning." "And when were the divorce documents submitted?" 8 weeks ago." Another pause. "Meet me at the office tomorrow. Bring all relevant documents." Vivian learned about her inheritance from Terence. It seemed my uncle anticipated a portion of Theodore's estate, but his absence from the will sparked Terence's usual reaction when reality didn't align with his expectations, making phone calls. Direct contact from Vivian indicated the nature of my uncle's relationship with my soon-to-be ex-wife. While I was in court for a wire fraud case, her number appeared on my phone 6 times within 2 hours. I did not respond. Upon the court recessing for lunch, I contacted Daniel instead. He informed me that Vivian had already consulted with her attorney, and they were modifying the petition to include the inheritance as a shared asset subject to equitable distribution. I sat outside Courtroom 5A of the federal courthouse on Market Street and took a deep breath. On what basis? Daniel explained they would argue that I had concealed the existence of the inheritance during the discovery process, knowing its value before Theodore's death, and failing to disclose it as discovery had closed. However, complications arose, necessitating an explanation about Vivian, a misunderstanding that became clear upon the arrival of the inheritance during our divorce, resembling a grenade. Vivian wasn't ignorant. She was exceptionally intelligent in terms of social dynamics and financial manipulation. She didn't pursue the $4 million inheritance out of mere greed. Instead, she sought it because, over 11 years, she observed my prudent, deliberate, step-by-step decision-making and predicted I would proceed as usual, craft a strong argument, present it rationally, and rely on due process. She had never witnessed me in a rage nor seen me ready to destroy something. This was her crucial misjudgment. Investigating what Vivian and Prescott were secretly engaged in for the past 18 months took me around 3 weeks of diligent research, undertaken after my father's visits and ongoing phone conversations with Daniel, as well as managing a persistent federal caseload that remained unfazed by personal crises. Here's what I uncovered. Prescott Harlow was not genuinely a personal trainer. In essence, he held the certification of a personal trainer, similar to how a man with a real estate license is technically an agent, even if he hasn't made a sale in 4 years. His actual enterprise, if you could call it that, involved introducing affluent married women to investment opportunities that were non-existent. He had orchestrated such schemes in 3 previous cities, Charlotte, Nashville, and Scottsdale, meeting his targets through exclusive fitness centers, always aiming for the wealthy women whose money stemmed from husbands, families, or inheritance. Over several months, he developed a rapport, built trust, fostered intimacy, and subsequently proposed a time-sensitive investment offer demanding substantial funds when opportune. In Charlotte, Beverly, a lady, lost $200,000 without her husband realizing the deception till later. The case was settled discreetly. Prescott relocated. In Nashville, Lorraine, a dental practice proprietor, transferred $160,000 to an LLC that ceased operations 6 months post-Prescott's departure. Her lawyer lodged a complaint with the state securities board, but no action ensued as Prescott had departed already. Matters became more complex in Scottsdale. An unnamed woman was on the verge of losing her home due to similar circumstances. A retired DEA agent, my husband, previously conducted work similar to mine: research, documentation, and file compilation. However, Prescott became aware of his efforts and departed before he could gather sufficient evidence for official reporting. I discovered this information through the tactics commonly employed by prosecutors: contacting people, asking questions, following the trail of documents, locating Beverly's husband via a professional association, having a confidential conversation with a Nashville woman, and connecting with the former DEA agent in Scottsdale through an FBI field office contact. Ultimately, I shared my findings with a colleague in the Financial Crimes Division. Vivienne remained unaware of this. She was under the impression that she was falling in love with a man who would provide exemplary care post-divorce, particularly upon her receiving a portion of $4,200,000. Unaware that the man she envisioned building her life with had been involved in this throughout their relationship, she discovered his investment fund, the one he'd promised to share details of once she had financial liquidity, was identical to the one used in 3 other cities. A complex emotion surfaced within me upon grasping this fact. Not contentment. Not at that moment. Instead, it resembled sorrow, for Vivienne, unwittingly, was both a perpetrator and victim in our marriage's downfall. I've witnessed such anguish frequently throughout my career. The realization that the reality one has known is fundamentally different strikes a distinct chord on people's faces. Yet, I had responsibilities. A court hearing was scheduled for Thursday in April. 8:45 a.m., the family courthouse on Filbert Street mirrored typical Philadelphia court dynamics in spring, straining under the weight of excessive caseload and limited resources. Daniel and I arrived at this time, my charcoal suit for closing arguments, a choice made with my father upon promotion to senior trial counsel, serving as an apt attire for notable occasions. Vivienne and her attorney, Bradford Ellison, known for tenacious discovery methods and a chin shaped by committee consensus, were already in the corridor. Prescott accompanied her, dressed in a blend of casual court attire, blazer, dark jeans, exuding an easy elegance that belied the time spent preparing it. He held Vivienne's back gently, and she noticed me first. I observed her whisper to Ellison, a brief, sidelong comment, then she returned her gaze to me, an action that will forever be etched in my memory. She gave a pronounced, dramatic eye roll, the type usually executed for an audience, signaling to those nearby that the person in question isn't worthy of serious attention. I held her stare for a brief moment, mirroring the polite nod I give to adversaries in federal court, and then I moved past her towards the courtroom entrance. Unbeknownst to her, 2 individuals were quietly observing from behind the bar, hidden among the spectators. They were Agent Carla DeWitt from the FBI's Financial Crimes Unit and Special Agent Terrence Abay from the Securities and Exchange Commission's Enforcement Division. Their presence was not for the family court proceedings. They were merely there to observe. The individuals present were due to my submission 3 weeks prior at the FBI field office on Arch Street of a 47-page document and statement. I believe you have a federal securities fraud case, and I can assist in constructing it. The family court session started promptly at 9:30. Ellison elucidated Vivienne's stance, exhibiting the assuredness of an individual familiar with such proceedings. He contended that the inheritance was a marital asset, as I had knowledge of its worth throughout the marriage. My grandfather's real estate holdings were publicly accessible information. Therefore, a diligent spouse, it was suggested, could reasonably anticipate profits from these assets. Additionally, Ellison emphasized the potential concerns surrounding the disclosure timeline as his most persuasive point. The judge, Honorable Richard Assant, aged 61, demonstrated the composure of an individual who had listened to every conceivable argument multiple times. Having served for 19 years on the bench, he was well acquainted with every iteration of arguments. Known for disrupting those who wasted his time unnecessarily, yet I had presented myself before him on 2 occasions involving cases extending into family court. I recognized he also garnered a reputation for meticulously focusing when something merited it. Daniel articulated our stance in a composed and concise manner. The inheritance lacked tangible existence as an asset during the marriage. Theodore Wyatt had passed away in February. Under Pennsylvania law, these assets were considered property discovered, not marital property, due to the inheritance occurring post-separation date. Vivian's counsel produced no compelling evidence of concealment. Ellison reiterated the constructive knowledge argument more forcefully this time, suggesting it was implausible to assume a man with my intellect and professional background remained oblivious to his grandfather's significant property holdings. Judge Assant scrutinized him through his glasses. "Mister, are you implying dishonesty? We are suggesting concealment of crucial information that amounts to you specifically inquired about it." In our view, Mr. Wyatt had knowledge of significant assets related to the marital estate and chose not to reveal them during the discovery process. That appears to be fraud, Your Honor, a pattern of hidden dealings. Judge Assant made a note, doing so with obvious intention, then fixed his gaze on me, a common judge's move before posing a question they already know the answer to. "Mr. Wyatt," he stated, "you serve as a federal prosecutor." "Correct, Your Honor. Have you encountered Pennsylvania's constructive fraud statute, specifically as it pertains to matrimonial cases?" "Yes, I am familiar with it, Your Honor." "In your professional judgment, does the plaintiff's argument regarding your grandfather's estate qualify as constructive fraud according to that statute?" I sensed Ellison contemplating an objection. However, he remained silent, understanding that a judge should not be interrupted while asking a question. "No, Your Honor," I responded, "and I believe the plaintiff's legal team is aware of this." What transpired next was unforeseen and not part of the family court proceedings. Yet it was something I had anticipated due to phone calls made 2 days prior, during which I received a heads-up in the cautious terminology of federal law enforcement about the potential overlap with the hearing. The courtroom door creaked open. Agent DeWitt entered, no longer disguised, now displaying credentials. Accompanying her was Agent Obie. They moved past the bar, the seating area for the gallery, where Vivian was seated with Prescott's hand on her arm, and proceeded towards a table that wasn't theirs. Special Agent Carla DeWitt, from the Federal Bureau of Investigation, spoke to Judge Assant. "Your Honor, I apologize for the intrusion. I am Special Agent Carla DeWitt. We have a federal arrest warrant for Prescott Harlow." She directed her gaze at Prescott. "For securities fraud, wire fraud, and conspiring to commit fraud in violation of Title 18 of the United States Code." A hush descended in the courtroom, lasting about 3 seconds before it was filled with commotion. Vivian uttered a noise I cannot exactly define, a mix between a query and an intake of breath. She turned towards Prescott, who had stiffened, exhibiting the immobility of someone weighing possible outcomes for the next 60 seconds. Ellison withdrew his chair from the table, prompting Judge Assant to lay down his pen. Prescott Harlow, who had spent 18 months persuading my spouse that he was her future, faced the 2 federal agents and remarked, "I believe there has been a misinterpretation." However, there was no misinterpretation. The accusations were extensive, encompassing 3 distinct counts of securities fraud in 4 states, 2 counts of wire fraud linked to the fund transfers from victims in Charlotte and Nashville, 1 count of conspiracy involving an associate in Scottsdale who managed the sham LLCs. The total amount defrauded collectively from all victims surpassed $800,000. Vivian was not indicted for any crimes. I wish to emphasize this, as I believe it is crucial. She was a victim even if she wasn't aware of it yet. $47,000 transferred to an investment vehicle shown by Prescott, funds from an account set up by her parents, have become evidence. Although she would retrieve a significant portion, she wouldn't receive any share of Theodore Wyatt's estate. Judge Assant paused the hearing for 30 minutes to handle the arrest proceedings. After resuming, Ellison asked for a delay, which was denied by the judge. From the bench, he swiftly ruled that the inheritance qualified as discovered property under Pennsylvania law. No convincing evidence of concealment or fraudulent acts were found, and the amended petition was dismissed. As he spoke, he glanced at Vivian's table. Ellison adjusted his jacket and took notes, while Vivian fixed her gaze on the table, where Prescott's hand had rested on her arm mere minutes ago. Judge Assant spoke with his customary terse manner, emphasizing emphasis. The court observed, Mr. Wyatt, the defendant, seemed to disclose more crucial details than the other party had expected. He stated it only once. He didn't expand. He didn't have to. Afterward, I drove to my office on Market Street and spent an hour at my desk before doing anything else. It wasn't a celebration, though I can't quite put a label on what I was feeling. Rather, it was a need for a moment to comprehend the recent turn of events. I entered the courtroom that morning as a man who thought his ex-wife and her attorney believed they would outsmart me with legal tactics. They assumed I would react predictably under legal stress, meticulously, according to protocol, and in ways that could be anticipated and countered. They failed to consider that I had spent 2 decades mastering the art of perceiving beyond immediate sightlines. Unbeknownst to them, while Ellison was constructing an argument based on disclosure lapses, I was constructing something entirely distinct. As I pondered Theodore's letter, I recognized that merit and entitlement weren't synonymous. He had been discussing Terence and his other offspring, who believed they were entitled to the estate due to their blood relation. Yet the sentiment held true in my situation too, albeit differently. Vivian assumed she was owed a piece of my grandfather's life's work because she was once my spouse. Prescott thought he deserved others' money due to his ability to charm them. What they didn't grasp was that the realm I operated in, evidence gathering, documentation, and meticulously constructing a case over time, had rules they hadn't taken seriously. I phoned my father from the office. Raymond Wyatt picked up on the second ring. "I completed it, Dad," I stated. He fell silent for a brief while. "Grandfather often praised you for your diligence." "Yes, I remember. How are you, son?" I glanced out the window at Market Street, observing the passers-by and bus stops in the historic district that had shaped me, and then attempted to mold something common from me rather than what I'd ultimately become. "I'm fine," I replied. Let me share what transpired in the ensuing months, as the consequences of such events are often more intricate than the incidents themselves. Vivian sought bankruptcy protection in August. The transfer she made to Prescott's fund, coupled with Ellison's legal fees and an apartment lease she took expecting a settlement that never materialized, had placed her far beyond her financial capabilities. I share this not out of glee, but because it's the reality, and in my experience, reality is always more practical than a version that soothes feelings. Prescott Harlow faced 7 charges in federal court, with trial set for the ensuing spring. 3 of his past victims decided to testify. The Scottsdale DEA agent, Vincent Cordero, provided a deposition that was widely deemed damaging. I wasn't part of the prosecution due to conflict of interest rules. However, I kept abreast of the case as it seemed connected to my own narrative, albeit indirectly. In June, my uncle Terence emailed me, suggesting he thought Theodore had been influenced in his later years into altering a will that once named Terence as a beneficiary, and was considering challenging the estate through legal means. I forwarded this email to Daniel Rourke. Daniel responded simply, "Let him." Eventually, Terence decided not to contest the estate. I assume Daniel made a phone call in response to my forwarding the email. $4.2 million remained after deducting estate taxes and legal fees, resulting in around $3 million. I utilized the money in ways Theodore would have endorsed. I purchased a house in Mayfair where my grandfather had resided since 1968. I had no plans to inhabit it myself, but I didn't want someone else to possess it. The chessboard where he taught me still stands at the kitchen table. The coffee maker remains on the countertop. Occasionally, when my workload permits, I visit there on Sunday mornings and sit at that table, sipping coffee and contemplating the significance of constructing something steadily over 50 years, and bequeathing it to the person who asked the appropriate question. I established a scholarship fund at Temple University for first-generation law students from North Philadelphia. Raymond Wyatt was present at the unveiling event. He wore a new suit, and his expression mirrored his excessive pride yet reluctance to openly express it. I cautiously allocated my remaining funds, eschewing melodrama, through a certified financial consultant whom I meticulously screened to the amusement of my peers and self-assured satisfaction. Currently, I'm employed as a federal prosecutor for the Eastern District of Pennsylvania, still dedicating myself to 60-hour workweeks on cases that hold significance greater than most other thoughts that cross my mind. The apartment I relocated to following Chestnut Hill is less spacious and more tranquil compared to the house, and unlike the house, it feels entirely mine. For a considerable period, I contemplated Vivian's eye roll in that hallway, not with resentment but with genuine intrigue about its meaning, her judgments made during that moment, and the narrative she constructed about my character and abilities. She concluded that I was the same man she'd been married to for 11 years, the cautious one, the systematic one, the one who would concede graciously as this was what careful and methodical individuals did. Her assessment about my caution and meticulousness was accurate. However, she overlooked the fact that a carefully planned and calculated approach, given enough time and the proper motivation, can transform into something entirely different. My grandfather amassed $4 million over 50 years without anyone knowing. He wasn't deliberately hiding it. He was simply focused on his work, making shrewd decisions that would grow exponentially over time into something greater than what an outsider might have deemed possible. I am my grandfather's grandson. It's the price of being underestimated that the one doing the underestimating pays dearly, not the underestimated. I don't know where Vivian is now, but I sincerely hope she is thriving. I wish she navigated her path past Prescott's actions towards her. Be aware his actions affected her regardless of her role in our marriage. Victimhood and guilt aren't opposite entities. I've debated both sides in federal court. May she be in a place that doesn't require a settlement for survival. May the man she confides in deserve it. I wish many things for her, but they're not my concerns anymore now. Upon my last visit to the Mayfair house in May, I found something I hadn't seen before. A note hidden inside the chest set Theodore and I used since I was 8. Not a fresh note. The paper was worn, its folds soft, his handwriting faded yet readable. It said, "Garrison. The end game isn't about the final move. It's about the 15 moves you made before the opponent grasped your strategy." I kept it in my wallet, carrying it everywhere. It's not about a courtroom moment or money. Garrison kept his construction project secret from everyone. He simply constructed it silently while those around him had already shaped their version of the story's conclusion. I believe this is the real takeaway. People who underestimate you are inadvertently helping you. They stop observing. They become complacent. And it's precisely at these moments that you do your finest work. So if you find yourself in a phase where someone has dismissed you, that's great. Let them. Post a comment below and share an instance when someone underestimated you, only to regret it later. I'm truly curious. And if you're not subscribed yet, why wait? This is the channel for such instances.